Okay, let's go over some of these SCOTUS cases. We're going to start off with Trump versus United States. This is the big one everyone's talking about. Presidential immunity. What has happened here? Well, it was a 6-3 decision along ideological lines. You had both sides agreeing on one thing, and then they separated on the other. So you had both sides agreeing that a former president can be prosecuted for unofficial acts committed while in office. So this is not complete immunity, which is what the Trump team seemed to be asking for. This is instead partial immunity in that, no, you're not immune from everything when you're president of the United States. If you're committing acts that are unofficial, and by the way, we'll let the courts kind of decide on some of those, what's official and what's unofficial. You could be prosecuted for those. But if it's clear-cut constitutional rules for you, constitutional powers within the presidency, then you're immune to that. So the liberal justices, this was very much ideological. The liberal justices totally disagreed with that. One thing that Chief Justice John Roberts reiterated, and I think one of the reasons why they went down this path in the decision, was that there's this concern of the threat of constant criminal charges against presidents, against future presidents, that we've opened up this can of worms, which we have with Donald Trump. This is the first time we've ever had a president be charged with crimes while he was in office. And they're thinking, the justices are thinking, this wouldn't be the last, that there would be more prosecutions and more of this lawfare and going after political opponents in this way over and over and over again. And so one of the reasons why they decided to rule the way they did was because they wanted to prevent that sort of chilling effect on the presidency where somebody decides to run for president or they get into office and they worry that their political opponents are just going to come after them using lawfare. But they had to kind of weigh this sort of, the threat of that sort of paralysis that a president would get into office and not do anything because they're constantly afraid of being prosecuted by their political opponents. That paralysis with impunity. Are we going to make presidents of the United States above the law, or are we going to protect the office of the presidency? And I can understand that dilemma. Now, many people in the media right now are saying, oh, this is terrible. We've just now anointed the president as king. The president could go around and kill people, and it's no big, as long as it's done in the official capacity, it's no big deal. If they just command SEAL Team 6 to do it, then it's not that big of a deal. That's a bit of that's not really what the courts decided on, but what the courts were trying to weigh out was what is best going forward. Should a president have this constant threat looming above them, or should a president be allowed to be president of the United States and make decisions and have some freedom within that office? So they ultimately decided to go with the second option, which was allow the president some freedom and some latitude to make decisions without fear of any sort of prosecution. Chief Justice John Roberts wrote in the majority opinion, he said, "This case is the first criminal prosecution in our nation's history of a former president for actions taken during his presidency. We are called upon to consider whether and under what circumstances such a prosecution may proceed. Doing so requires careful assessment of the scope of presidential power under the Constitution. We undertake that responsibility conscious that we must not confuse the issue of a power's validity with the cause it is invoked to promote, but must instead focus on the enduring consequences upon the balanced power structure of our republic." Now, Justice Sonia Sotomayor wrote in the dissent, which was joined by Kagan and Brown-Jackson, she said, when he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune. And then Robert says, oh, come on, you're overreacting. That's what he's saying to this. He's like, this is not what the court is deciding right now. The court is saying that, he's allowed to have conversations with people. We're not talking about taking people out, political opponents out with SEAL Team 6 or staging coups. Robert said that they're overreacting. He said that if there is a problem, then impeachment is the remedy. But the problem is that, he's saying there is something, it's called impeachment. Impeachment, though, is not always a remedy, especially if a president does something when they're just like at the tail end and they're out of office, and now they're out of office and you can't impeach them anymore. So what do you do when you find out that they've done some tricky things? They've done some things under the table that are really sneaky. What do you do in that point, in that instance? So he doesn't really address that. So when that's kind of a line of thinking that's brought up, and he doesn't really say anything about that. He seems to be more focused on the threat. The majority justices seem to be more focused on the threat of presidential authority than the prosecution for official acts, that what that could end up being in these hypotheticals, because really we're talking about a bunch of hypotheticals. And he's more worried about the non-hypothetical, which is what we're experiencing right now, which is lawfare against presidents of the United States. And of course, there's Republicans who are chomping at the bit to go after Biden when he's out of the office. And this would be something that we would see continue over and over and over again. Now, in my opinion, no president or any politician ever should have any immunity from anything ever. I think that is just antithetical to what this nation is supposed to be about. It's against democracy. It's against a free nation, a free people. You cannot have a leader who has immunity from anything. We need to be able to hold our leaders accountable for anything and everything as we so choose as the people. However, that being said, even though I on principle believe that nobody at all, not even the president of the United States, should be above the law no matter what capacity they're acting in. So I don't care if you're acting on behalf of your company as CEO or if you're acting on behalf of the country as president of the United States. If you do something that is against the people or against what you should be doing, then I think you should be prosecuted for that. That being said, I understand the very unique situation we're in right now, which is there is a serious issue with lawfare and going after political opponents, and that's only going to get worse. I mean, we've seen what they've done to Donald Trump, and I do believe that if there's other populist candidates that get into office, the elites will try lawfare to take them out. And this shields them a little bit, but only if the person has served as president of the United States. But we've seen what they're capable of. We've seen that, they will try to oust. They tried to impeach him twice. They've tried to pin an insurrection on him, even though he very clearly told the people who were at January 6th to peacefully protest. That came right out of his mouth. He never encouraged violence, never encouraged them to stop the vote. But that doesn't matter. They've twisted everything to just go after him. And we see what they're capable of doing, and that's not going to stop with Donald Trump. And already, as it is, the presidents of the United States, not just Donald Trump, but all of them, have committed such heinous crimes without facing any sort of consequences that I don't know what the difference is. I mean, if you're able to just drone little children on school buses, if you're able to support genocides and provide bombs to genocidal governments, that is as bad as it gets. I don't know what's worse than that. What is worse than that? Dropping nukes on Japan twice. I mean, we can argue all day whether or not you think that was a good idea, but it was a terrible thing that happened to all of these civilians. There's been a number of things that presidents have done. And I mean, war crimes, marching us into Iraq under the pretense and lying to us in order to get us there. I mean, there have been so many things that presidents have done, and they've never faced a day of consequence that I don't really understand what the issue is. It's, in this case, only about political persecution. That would be the only time where this would shield a president from heinous acts, is only when their political opponents are going to go after them, because they're already shielded anytime they do anything else. So it doesn't matter. They're not facing any none of them face war crimes ever. Torture programs, no big deal. Immune. If Sotomayor wants to cry about something, it's the immunity of all these presidents after wars and droning and talking about taking out Julian Assange and bombing children and aiding and abetting genocide. Nobody has been held accountable for any of these extremely atrocious, the worst crimes you could think of. The worst crimes, the worst is blowing up little children. That's as bad as it gets. And yet not a single one of them have ever faced anything for it. So honestly, even though Sotomayor wants to say, oh, he could now Order Navy SEAL Team 6 to assassinate a political rival, immune. Organize a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, immune, immune. Oh, they're already immune from practically everything and anything. This would protect them from political persecution more than anything, because that's the only time this would ever be used. Otherwise, these guys are all they're all in cahoots. They're all thinking the same way. So, this is, I mean, what's the difference really? What is the difference with Sotomayor and these liberals that are crying about it? I really don't know what the difference is. And since the president already can commit any crime they want with impunity as it is, then I do understand the logic in protecting this country from reeling into a total and complete banana republic where all of these elite establishment idiots get together and just persecute each other politically. It's one thing if they did it on behalf of the American people and we actually got something from it. We actually got justice would be nice, right? That would be one thing, but that's not what they're trying to protect. And that's not what they're caring about. And so I would like to protect us in some ways from this lawfare political persecution circus that we've clearly entered into. So that's that case. I think it's inconsequential. I think people are overreacting. The president already does a bunch of crap that nobody cares about. They already commit all kinds of war crimes and torture and aid and abet genocide, and they're able to do that. I mean, it doesn't get any worse than that. And not only that, but Justice John Roberts is saying, look, it's for the courts to decide. So the court will decide if he was acting. Basically, what this would do is it puts it on the prosecution. It should be on the prosecution to prove that the president of the United States operated in a capacity that was for their own gain, outside of their official capacity, but for themselves selfishly, and that's it. They would have to prove that rather than kind of willy-nilly saying, we think you did, yeah, okay, that might have been within your scope, but we think you operated, your motive was wrong, and so now we could charge you with a crime. It's incumbent upon them to actually prove that before the president could be charged with that crime, because there is immunity from that. So it just puts a little bit more on them, and I think that's not a bad thing. I don't think it's ever a bad thing to put a little bit more pressure on the bureaucracies or administrations or prosecutions. I don't think there's anything wrong in making them have to prove a little bit more, saying you got to show us a little bit more evidence. All right, let's move on to the Murthy versus Missouri case. This used to be called Missouri versus Biden. And this is with you guys know the plaintiffs in this, Aaron Kheriaty. We've had them on our show, Dr. Aaron Kheriaty, Dr. Martin Kulldorff, Dr. Jay Bhattacharya. There's also Jim Hoft in this, and Jill Hines. Now, this is the lawsuit that has to do with social media censoring. This is what the Twitter files uncovered, was that the government was pressuring Twitter and other social media platforms to censor certain true information because it went against what the government wanted us to hear. So the lawsuit alleges that President Joe Biden and his administration were working with social media giants such as Meta, Twitter, and YouTube to censor and suppress free speech, including truthful information, all of it related to COVID-19 in this particular case, and election integrity and other topics under the guise of combating misinformation. So we've heard this all before. Now let's go through the timeline of this case, and then I'll catch you up to where we are today. Hearings for the case started in May of 2023. Now, if you remember, Judge Doughty, this was on July 4th of last year, Independence Day, and it was a win that we all celebrated, where this judge put a preliminary injunction against several Biden administration officials from contacting social media services, these social media sites, and urging them to censor certain information. So he put an injunction, meaning he told them you have to cease and desist. You can no longer, and he listed the who in the administration and which government agencies in the administration couldn't contact these social media companies about potential misinformation and things that they're worried about. So he put that injunction on them. Well, then in September, of that year, of last year, the Fifth Circuit Court ended up upholding this injunction, saying, yeah, the government can't go around contacting social media companies to under the, with the intention of getting them to censor people or certain content. But what the Fifth Circuit did was they narrowed it. So they said, okay, we agree, but we think that the injunction that was originally imposed by Judge Doughty was too broad. So we're going to narrow it a bit. And they narrowed the scope on who could contact social media and about what specifically. Well, then in October, a month later, the Supreme Court agreed to hear the case. And they then heard the case. And at that time, they decided to lift the injunction on the government. So lift the ban on the government from talking to social media companies. And that was heavily, I would say that there was a lot of dissent there from Alito, Thomas, and Gorsuch, who said, government censorship of private speech is antithetical to our democratic form of government, and therefore today's decision is highly disturbing. And that's what they said about lifting of the injunction back in October. They just felt like this is a major free speech case, and the government infringed on the rights of people, and this is disturbing to allow them to continue to do it. Well, then the Supreme Court just recently issued its decision, and it was a 6-3 majority determining that neither the states nor other respondents had any standing, and they ended up reversing the Fifth Circuit decision. So they basically have now allowed the government, the Supreme Court, as of last week, has now lifted the injunction, allowing the government to continue communicating with social media companies to censor Americans. So this was a loss. This was not the way that many of us thought that this would go. In fact, the Fifth Circuit and the lower court all thought that the Supreme Court would read the merits of the case and say, yeah, the government completely went in there and coerced essentially these social media companies to censor certain Americans, and that's against the First Amendment. But the Supreme Court didn't rule that way last week. They said, no, we're going to lift this injunction. But the thing to take away from this is they didn't do it on the merits. They didn't say it's okay for the government to censor Americans. It's okay for the government to contact social media companies and tell them what they believe is misinformation and pressure them into silencing people spreading this so-called misinformation. They instead just kind of kicked the case and said, you don't have any standing, is what they said. This is about standing. So it's like a technicality. It was Justice Amy Coney Barrett wrote the opinion. She stated, to establish standing, the plaintiffs must demonstrate a substantial risk that in the near future, they will suffer an injury that is traceable to a government defendant and redressable by the injunction they seek. Because no plaintiff has carried that burden, none has standing to seek a preliminary injunction. So she's basically saying, you didn't give us enough evidence that the government was actively trying to censor and harm your First Amendment rights. So unless you could come up with enough, well, she didn't even say that. She just said, you didn't give us enough evidence that the government harmed you directly, that this was directly onto you, and there wasn't enough evidence that they would then potentially do this again. That is not, so this case isn't dead. That's the big question. And by the way, Alito, Thomas, and Gorsuch once again dissented on this. Those three said, in fact, Alito wrote the dissent, and he wrote, this is one of the most important free speech cases to reach this court in years. He said that the respondents hadn't brought enough evidence to suggest the government's actions were unconstitutional and that the court shirks that duty. Oh, he says that they had brought enough evidence. So he said this is the most important free speech case to reach this court in years, and the respondents had brought enough evidence to suggest the government's actions were unconstitutional, but that the court shirks that duty and thus permits the successful campaign of coercion in this case to stand as an attractive model for future officials who want to control what the people say, hear, and think. That is regrettable, he says. So not good. This is not a good decision. This was totally and completely against what all of us thought would actually happen in this case. It was a terrible defeat in a way. However, it's not over. This was just on the injunction. This wasn't on the actual case itself of free speech and whether or not the government infringed. This was just on the injunction, which is the temporary stopgap, the government cannot contact social media companies while this case is going through the courts. The case is still going through the courts. And what the plaintiffs have now learned is that the justices need more in order to eventually get to the point where they're going to rule in their favor, which they still could potentially if they get enough. So this is from from Health Freedom LA. Well, actually, first let me show you these. This is from Jen and Eunice. She's actually the attorney who's been representing this case. And she tweeted out, a majority of the Supreme Court did not hold today that the federal government censorship regime was lawful. It held that because operations were conducted in secret, plaintiffs didn't have enough evidence to prove they specifically were censored because of the government. So they were saying that these plaintiffs in particular didn't have enough standing because they didn't prove that the government harmed them. Now, there is another case making its way through, and it's Alex. What is Alex's last name? It just right now has completely, I've lost, you know who he is. Alex, let me see, COVID. I'm going to just Google this real quick, but he's got the SCOTUS case and he's potentially, who is it? Just right off the tip of my tongue, his name is it Berenson? Is that what his last name is? Right. So he's somebody that there's another case making its way. He was completely censored. It was way more targeted onto him. And there is a possibility that when that case hits the Supreme Court, they rule, it's really kind of up to him now. He's up to bat, but he's got more evidence. And so there's a possibility that SCOTUS takes up that case and says, yeah, social media companies completely engaged in this and they cannot be doing that. So that is still a possibility. Dr. Aaron Kheriaty wrote this in his Substack blog. He said, in the meantime, rest assured that we will continue to fight the government's censorship leviathan in court. As the case goes back to the district court for trial, we anticipate more discovery, which will allow us to continue to shine a light on the government's unconstitutional behavior. Perhaps we'll uncover communications that even meet the Supreme Court's impossibly high traceability standard. This is not the end, my friends, just one battle in what will prove to be a long war. Onwards, he writes. So people are still hopeful that this isn't over. This is from Health Freedom LA. They've been very much involved in this case, and they wrote in their Substack that it was not the SCOTUS decision we were hoping for, but thankfully the justices made no ruling on the merits, instead making their decision based on standing. Hence, Missouri versus Biden, which is now Murthy versus Missouri, moves forward without the benefit of the injunction, which would have prevented any further government censorship of speech on social media while the case proceeds. So, but this person wrote, despite misleading headlines, Missouri versus Biden is not over. So don't think it's over just because this setback with the Supreme Court. It is still very much alive and well. And there are other cases similar to it, and they might actually prevail in court, really shining on the light on the government going after social media and trying to censor many of us. Thank you so much for watching this clip from the full show, which you can catch Monday through Friday, 5 p.m. Pacific, 8 p.m. Eastern at KimIversonShow.com. Thank you guys so much for watching.